Thanks, Dina. Good morning, everyone. It is still morning, and I know all of us in this webinar are feeling energized and focused, and that's really terrific. Perhaps a little less terrific for employers, and for those of us who represent employers, is that the NLRB is also feeling re-energized, and it's got its sights set on non-union employers, which is most of you. So that's correct. This is not the conventional union segment of the program where you non-union folks might tune out just a little bit. We're in the closing days of a month that people are calling Striketober because there's been so many strikes and so much labor unrest around the country. And yes, it's Striketober. That's a real thing. You can Google it. And all this energy and activity in the workplace matters for non-union employers. And for those of you, I know we have some public sector attendees who are not covered by the NLRA. Stay tuned, because a lot of the principles you'll hear here also apply under your state and local bargaining statutes. So before we dive in, I just want to give you a quick overview of what we're going to cover. I'm going to start with a short refresher on the NLRA and how it applies to non-union employees. Then I'll talk a little bit about the agency itself. Garrett will then talk about some of the areas where the NLRB is going to be active in the non-union space. And I'll round out that list of areas to watch for. Then I'll touch on some legislative developments, and we'll close with a couple of hot topic cases of interest relating to COVID and political activity in the workplace. Again, non-union employers and interacting with the NLRA. Okay, so here we go. Can we have the next slide? Oh, I'm sorry, can you go back? We're already on the next slide. Thank you. So quick refresher. The NLRA, it's been around for a long time, since 1935. It was enacted during the New Deal, and it is not a neutral piece of legislation. It was designed to protect employees who are pushing back against their abusive employers, and to rebalance the power dynamic between employer and employee by giving employees the right to engage in collective action. Next slide, please. So the core of the NLRA is Section 7. These are rights, Section 7 rights, that apply to all non-supervisory employees, union or non-union. And Section 7 states that employees shall have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection, and shall also have the right to refrain from any or all of such activities. So it's a mouthful, but all that text breaks down into three basic rights or categories of rights. One, the right to organize or to refrain from doing so. Two, for those employees who have organized and formed a union, they have the right to bargain collectively. And three, they have the right to engage in other protected concerted activity. So what does that mean? Well, concerted activity is activity engaged in, with, or on the authority of other employees, including activity intended to incite group action or speaking on behalf of other employees about terms and conditions of employment. Essentially, that means one or more employees banding together for the benefit of more than one employee. So you can even have one employee who is engaged in concerted activity if that activity is for the benefit of other coworkers. Next slide, please. So the key elements of the Act of the NLRA, we just covered the main one, Section 7, which covers, again, union and non-union employees. And the rest of these key elements are things most of us are familiar with. The Act established the NLRB and its general counsel. I'll talk about that in a couple minutes. It governs the representation election process, regulates the collective bargaining process where there is a union, and the Act has a list of unfair labor practices, ULPs, which are for both unions and employers, which are violations of the rights afforded by the Act. And one of those ULPs is interference with employees' Section 7 rights. So again, if an employer interferes with an employee's Section 7 rights, that's an unfair labor practice, whether or not that employee is represented by a union. Next slide, please. So the role of the NLRB, again, probably pretty familiar stuff. The NLRB oversees union elections, investigates ULP charges. It decides cases either at the administrative trial level by an ALJ, administrative law judge, or through appeals to the board itself. And the board issues binding precedential decisions. And the NLRB can also promulgate administrative regulations which it has done more frequently in recent years. Next slide, please. So the board right now, this is the current board. Members of the board are nominated by the president and confirmed by the Senate. And a majority of the board right now are Democratic Party appointees. And what that means is that for the foreseeable future, the board has a majority that is going to take a decidedly expansive view of employee rights and union rights under the Act. Next slide, please. So the other key player under the NLRA is the General Counsel. And the NLRB GC is one of maybe 2 or 3 federal agency general counsel who is nominated by the president and confirmed by the Senate. And that's significant because it means the position is independent from the board itself and serves a 4-year term. The GC is responsible for investigating and prosecuting ULP cases, and she also oversees all of the regional offices of the NLRB around the country. All of the regional directors, they all report to the general counsel. The new current general counsel is Jennifer Abruzzo, who started her term in July. And she is a longtime NLRB staffer who rose up through the ranks to a very high level at the agency. She then left during the Trump administration. She went to work for the Communication Workers of America. It's a large national union, which might tell you where her sympathies lie. And then she came back at the request and nomination of President Biden. So why are we talking so much about the new GC? Well, as I noted, the GC is the prosecutor of NLRA violations. And that role gives the GC really a ton of influence over the way that the NLRA will be interpreted and applied. The GC sets the priorities of what types of cases the agency will pursue, what industries might be targeted, what legal theories will be advanced. And she does this by picking the cases that will be the priorities for her, the cases which provide an opportunity to reverse precedents that she doesn't agree with, or which present an opportunity to create new law that aligns with her view of the Act. Next slide, please. So in her first few months in office, Ms. Abruzzo has made it clear that she does intend to seek reversal of many, if not all, of the board's employer-friendly decisions that were issued under the prior administration. She also has identified areas of the law that have not been in flux, that have been settled for many, many years, but which she appears interested in changing as well. And many of the areas that she has targeted, or she has identified that she is targeting, could have major implications, again, for non-union employers. Unionized employers are going to get rougher treatment at the NLRB. There's no question about that as well. But here we're focusing on the areas of the law that Ms. Abruzzo has identified as her targets that could have an impact on non-union employers and employees. And so now I'm going to hand it off to Garrett. He'll take us through some of those key areas and what we expect to see happen there.
Yeah, thanks, Dan. So we certainly expect to see the board make a number of broad and consequential changes that certainly fall into line with these planned changes that the General Counsel has spelled out. And one of those expected changes is likely to come in the way that the board reviews workplace handbooks. So to understand where the board is likely to go, we need to look at where they've been. So let's look back briefly as far back as roughly 2012, when the board really began to sink its teeth into a lot of these workplace handbooks. This trend largely began by the board taking on cases and in the course of investigating those cases, requesting to look at various policies and handbooks, regardless of whether it actually mattered for the charge that they had in front of them. They would review those under a pretty broad reading of prior case law and find additional violations of the National Labor Relations Act, really regardless of whether it, again, pertained to the charge that was in front of them. Now, predictably, this led to a number of cases being filed with the board for alleged violations of the Act based on these policies, because the board utilized this broader standard. And that broader standard basically said that if the board decided that a policy could be reasonably construed to violate the Act, then the policy could not stand. Now, critics of this broader standard largely said, look, this is entirely too broad. It doesn't take into consideration whether the policy has actually been used to violate the Section 7 rights of the employees, and it does not look to whether there's a legitimate justification for that policy on the books. So when the board changed political majorities in 2017 under the Trump board, this handbook review precedent was reversed in favor of what is currently in place, though likely not for long, which largely balances the policy's potential impact on Section 7 rights with a company's justification for utilizing the policy. Like I said, this standard is likely to be short-lived. Now that the board has gone back to pre-2017 political makeup, and in light of the General Counsel's new memo detailing our plans, it's likely that the board will revert back to the reasonably construed standard, and again take aim at these workplace policies and they're without regard to their effect or to actually how they're used in the workplace, or whether there is any kind of justification, legitimate business justification for those policies. So I wanted to point out just a couple of ways that are likely to have broad impacts in the workforce overall, regardless of union representation. If we can go to the next slide. One of those common policies that's likely to receive stricter scrutiny from the board is the way in which companies utilize confidentiality agreements with employees. Now, again, we need to look back at what the board has done before. And pre-2017, the board put into place a number of rules that restricted, for example, policies that required confidentiality from employees taking part in company investigations. Also restricting the way that companies used confidentiality provisions of things like separation agreements. And the pre-Trump board justified its decisions to strike down these kinds of policies by arguing basically that workers shouldn't be required to keep as confidential things that affect the terms and conditions of their employment. Obviously, there were critics that said this runs against what has historically been done. Confidentiality provisions are used in things like separation agreements all the time. And so in 2019, during the Trump board, the board changed course and largely said that companies would be allowed to use these kinds of agreements. However, as I stated before, this is likely to be short-lived. The General Counsel has largely indicated that these kinds of policies are going to be put on the chopping block, which is likely to affect the way that pretty much all companies, regardless of unionization status, utilize things like confidentiality agreements and various policies or contracts or agreements that it has with various members of its employment staff. If we can go to the next slide. Another thing that's likely to receive stricter scrutiny are companies' communication systems. Back in 2014, the board issued a decision called Purple Communications that I'm sure a lot of employers have heard about or had many discussions about. And that decision prohibited employers from restricting employees' use of the company's email systems that was being used on non-working time for non-work related issues. And in 2019, the Trump board reversed that decision and said that no, employers can lawfully restrict the communication system, the use of their communication systems for non-work purposes, so long as the policy is applied in a non-discriminatory way. This line of cases it's gone back and forth quite a bit, and it's likely to be the beach ball that just never drops. It keeps getting batted around from side to side. And what is no surprise is that the new General Counsel has identified that 2019 case as one that's ripe for reversal. And she's expressed not only an interest to return back to the Purple Communication Standard, but also to broaden its applicability by expanding it to communication systems such as Discord, Slack, GroupMe, or other communication systems that are used in a more modern workplace. Again, this is regardless of unionization status and will likely affect companies on a broader scale, or at least leave them liable to a charge brought before the National Labor Relations Board. Go to the next slide. So moving a little bit away from specific policies, the board's General Counsel has also expressed interest in broadening some of the legal standards regarding who is allowed on employer property, when and in what capacity they are allowed to be present. And one of those includes specifically whether and when non-union affiliated employees, when those employees have a right to representation, which usually comes in the form of a coworker because you're not represented by a union, during certain meetings or interviews that could lead to disciplinary action. Now, as you can see here, the board is flip-flopped and really goes back further than this, roughly over the last 40 years, on whether those non-union employees enjoy a right to have a coworker present during that kind of meeting that could lead to disciplinary action. So in 2000, the board said yes, even non-union employees have what are known as Weingarten rights, a right to have a representative present. And pretty quickly thereafter, in 2004, the board reversed itself and said, no, we're not extending Weingarten rights out to non-union employees. The new general counsel has at least expressed an interest in finding cases to potentially return back to the 2000 standard, where employees could request that a coworker be present, which would cause delays to various proceedings that the companies may try to get into with their employees and affect how those processes run. Dan?
Thank you, Garrett. Can we move on to the next slide, please? So the General Counsel is also explicitly looking to toughen the remedies that are imposed on employers for violating the Act. And this is obviously important because we all care about remedies, but it's particularly important because I think in a lot of cases, many employers viewed the risk when you go in front of the NLRB in like a discharge case or other types of cases as pretty minimal, right? You might have to pay back pay if you were found to unlawfully terminate an employee. You might get a cease and desist order, slap on the wrist. It was worth the risk. Well, Ms. Abruzzo is aware of that, and she has encouraged the regions to request a, quote, full panoply of remedies from the board in the cases they are bringing to ensure that victims of unlawful conduct are made whole for losses suffered as a result of unfair labor practice. And a memo she issued back in September listed a number of the remedies that regions should request. And one of those remedies is consequential damages, which the board recently agreed to explore in a case. And specifically, the board is considering whether consequential damages can be awarded as part of a make-whole remedy for an employee who's been unlawfully terminated. And these types of damages would be separate from the traditional loss of back pay and benefits. They could include healthcare expenses that were incurred due to the loss of health insurance that resulted from a termination. Compensation for credit card late fees that the employee incurred because after losing their job, the employee can no longer make their credit card payments. Damages for the loss of a home or a car, similar that the employee suffered as a result of an unlawful discharge that thereby prevented the employee from keeping up with payments. So this is a far-reaching change in the type of exposure that an employer could face from a charge alleging an unlawful discharge of an employee. And again, these remedies apply whether or not the employee is represented by a union. Other new remedies that Mr. Abruzzo wants to seek include front pay, liquidated damages. She's called for special forms of relief for undocumented workers. And also interesting in the non-union world, for unlawful conduct committed during an organizing drive, Ms. Abruzzo is urging the regions to seek expansive remedies like union access to employer property during the organizing drive, reimbursement by the employer for the cost that the union incurs in its organizing activity, paying the union for organizing your employees, NLRB access to the employer's property and records to monitor compliance with the NLRB's orders, and my favorite, training of employees, supervisors, and managers of employee rights under the Act. So part of a remedy for unlawful activity during an organizing drive would be to train your employees on their rights under the Act, essentially union campaigning. So again, non-union employers could find themselves facing far stiffer remedial orders for ULPs for unfair labor practices, including terms that could foster even more employee activism and generate more organizing activity. Next slide, please. The last area we're covering today on Abruzzo's agenda is employee status. Now, independent contractors are not covered by the NLRA. They have no Section 7 rights, no right to unionize. They're simply not covered. So the definition of employee status that the board uses is significant because it determines the scope of the coverage of the law. And there was a Trump-era NLRB decision that lowered the bar for independent contractor status, that sort of made more workers excluded from the Act's coverage. Ms. Abruzzo named that decision as one of her targets for reversal. But more ominously for employers, she also appears interested in pushing the theory that a misclassification of an employee itself could be a violation of the NLRA. So an employer who mistakenly classifies an employee as an independent contractor, even totally in good faith, could find itself in violation of the law and facing remedies that make it easier for employees to organize. So non-union employers, particularly those that rely on a lot of contractors, should be aware of this issue as it develops, and we will be monitoring it. I see Dina is here. Do we need to wrap up at this moment, or should I skip to the last slide there?
Yeah, sure. Finish up, Dan.
Okay, so let's move on to the last slide. We're going to cover the PRO Act, which is legislation that's in Congress. All you need to know right now is that it's stalled. Follow our blog. We'll let you know if anything happens there. If we can move to the next slide, please. So the last area I want to cover, got that plug in there for the blog. Couple hot topics that I think will be of interest to employers here. These were decisions issued by the NLRB Advice Division, which gives guidance to regional offices on how to handle particular cases. So in renewal by Anderson, a group of employees, non-union employees, were required to use a group chat app, GroupMe, to communicate about work assignments and operations. One employee used the app to message his coworkers about rising COVID rates in the area, expressing concern about the safety of coming to work. The employer didn't like that, told the employee to stop, and then remove the employee from the group chat. The employer told the employee he couldn't. The employee then said, "I'm not going to report to work because I don't think it's safe here, and I don't think it's safe that you're preventing me from discussing these dangers with my coworkers." The employer considered that a resignation. The NLRB said it was a constructive discharge, found that the messages on the GroupMe app were protected activity, and that the employer violated the employee's Section 7 rights by prohibiting him from discussing safety issues on the group chat app. So the takeaway here is discussions about COVID dangers and risks can qualify as protected concerted activity. And two, that the NLRB seems clearly aimed at making all channels of communication that an employer uses available to employees to discuss their working conditions. So if you see any of those things happening, pause and consider them rather than taking quick action because there could be NLRA exposure there. And I'll leave it there and hand it off to Dina. Thank you very much.